Yeah. 2 seconds, it was 16. And you're like, I haven't used these yet. Lance, you want to swing some more?
It's kind of fishing.
Except
Super is full. I'm a little surprised they posted that. So,
for 2 people.
yeah, well, I reposted on the bar. So hopefully that was. You're back.
Yeah, of course, we can keep it like.
Cooler. Put them here. He went to go head back out there with his fishing pole that here, like.
Like, no, that's not on here. Lance is still not.
I'm thinking to do things another.
Oh my gosh, can't wait to see that appeal.
Oh, I'm not trying to get like a state.
But you can't change the first session.
Actually,
Oh, no, I really.
Yeah, sorry, I need it in New Meadows, that's why I need there. So.
actually, the timeline, there's a cake.
Right, well, there's quite a bit of women in the class. Or they're maybe. I was ready, I'm on the different. I'm sorry. My dog. No, you just can do that. You're going to be taking the real.
And we get a copy of the posting section. Okay, great.
Oh, yeah, thank you. Perfect. First, perfect. All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 14th District of Texas is now in session.
Thank you. Please be seated. Good afternoon and welcome to today's session of the 14th Court of Appeals. We are obviously in Waco, Texas, and appearing today thanks to the hospitality of the Waco Court of Appeals in hearing this case. And we have one case on the docket. Number 1423-799 CV Farmers Texas County Mutual Insurance Company versus Bladenick. With me today is, to my right, Justice Francis Borleo, and to my left, Justice Jerry Zimmerer, and I am Justice Kevin Jewell. And we will take announcements on this case. So for the appellant, are you ready to proceed? And how much time would you like for rebuttal?
Yes, Your Honor, 5 minutes, please.
Okay. And counsel for appellee, are you ready to proceed?
Yes, Your Honor.
Okay, then the court is ready to hear argument from the appellant.
May I please the court? Good afternoon, Rose Doda for the appellant. The contractual language of this policy is clear. Farmers will pay up to, but not more than, $50,000 for all damages flowing from each bodily injured person. In this case, the parties have stipulated that only one person sustained bodily injury, and Farmers has paid $50,000, the maximum under the policy, for all damages flowing from that bodily injured person. That decides this case. Farmers owes nothing more. For this accident, in which a daughter was struck by an uninsured driver with her mother as a bystander, the mother and the daughter share the same already exhausted policy limit. And this is under both the unambiguous language of the policy and under well-settled Texas law. I'll start with the unambiguous language of the policy. The relevant provisions are found in Part C of the policy, which is at Clerk's Record, page 43. And I want to draw the court's attention to the two relevant provisions, the insuring agreement and the limit of liability, that together define the scope of what farmers can be expected to pay under this policy. The insuring agreement lays out what claims are going to be covered, what a claimant could ask for and expect to be paid for. And the limit of liability, on the flip side of that, tells farmers how much it can expect to pay out for any specific claim. Think of it in terms of buckets of money that are available under this policy. These terms define one bucket of what's available. The insuring agreement says what goes in this bucket. And here, it's damages for claims because of bodily injury. So right away, we know if there's no bodily injury involved, the claim's not going to go in this bucket, and we're not even in this scenario. The limit of liability, on the other hand, tells us two things. It tells us how big is this bucket and how many buckets are there. Under this policy, no bucket is going to be bigger than $50,000. That's the each person limit. And that tells us how many buckets there are. It's each person who sustained bodily injury in any one accident. And finally, we know that regardless of the number of buckets, regardless of the number of bodily injured people, claims made, covered persons, Farmers is never going to pay more than $100,000. That's its maximum for each accident. So turning to the facts of this case, we have two very important stipulations of fact. One is that the daughter sustained bodily injury, and two, that the mother did not, although she did sustain mental anguish as a bystander. So we know already a couple of things. Since there's only one bodily injured person, only one $50,000 limit is going to apply. And Farmers paid the daughter $50,000.
Let me ask you this. If Jamie only had $15,000 of injury, would farmers owe an additional amount for the bystander damages up to 50,000?
Yes, Your Honor. It would owe whatever the remainder is up to the 50,000 and no more. So in this case, since the parties have stipulated that the mother is bringing a $50,000 claim, part of her claim, but not all of it, would be covered, again, up to that $50,000 limit. This each person, one bodily injured person, one $50,000 limit. It's a very clean, simple math problem in this case.
But if there had been 2 bodily injuries, would there be additional recovery?
Yes, Your Honor, because again, 2 bodily injuries, we're talking about 2 buckets of money. The only limit would be, of course, 50,000 for each person, adding up to the 100,000 accident limit.
Can I clarify something, in response to Judge Jewell's question? Were you saying that if, the daughter had $15,000 bodily injury damages, they would actually owe the mother, the remainder up to 50?
Yes, Your Honor. It's my understanding that her bystander claim would be covered under this policy because it arises from her observing her daughter's bodily injury in this one accident. And that, kind of negates the whole question of derivative that appeared in the party's briefing. Frankly, Your Honors, I think that's a bit of a red herring. Again, what comes down to is not whether the mother is covered under this policy. It's only whether there's anything left to recover beyond the $50,000 that's already been paid out. And there's not.
So your reading of the limit of liability language, where it says our maximum limit of liability for all damages for bodily injury sustained by any one person, you read that to say, or to mean, that all damages for bodily injury means all damages resulting from bodily injury.
Yes, Your Honor.
Okay, are there cases that have said that directly or have addressed that question directly?
No, Your Honor. I think, however, if we look at the policy itself under general principles of contract interpretation, we don't look at any specific term in isolation, but together, I think it becomes clear that this policy covers 3 specific types of coverage. There's bodily injury liability, property damage, and there's personal injury protection. And the only one that we're worried about today is the bodily injury liability. And so this whole section defines.
Is that actually the policy limits, the policy definition of bodily injury, or is that the statutory interpretation of bodily injury in the Texas insurance code?
This policy does not define bodily injury.
But the requirement to cover is decided by the Texas insurance code. Is that correct?
That's correct.
And the code says property damage and bodily injury. Is that right?
It does. I believe it also includes terms such as sickness and care. But this policy actually parrots exactly the language used in the Texas insurance code. Because there, the Texas insurance code says an insurer must provide coverage for damages because of bodily injury, and yet subject to limits liability for bodily injury.
So this is not something new that hasn't happened. I don't remember when the insurance code came out for a requirement for policies, but it's required that insurance companies in Texas offer policies, including bodily injury and property damage. So since that enactment until today, have insurance companies traditionally paid for bystander injuries as a separate claim?
No, Your Honor. And ample case law does support this. Nearly 40 years of cases going all the way back to the Texas Supreme Court's decision in McGovern v. Williams.
McGovern v. Williams, however, is a homeowner's insurance claim. Is that right?
I believe that's an automobile insurance company.
Oh, is it? Okay.
Yes, I think Trinity versus Cowan, perhaps Your Honor's thinking of.
Thank you.
That's a homeowner's insurance. But yes, through this line of case law, starting with McGovern, courts have consistently looked at the language of nearly identical policies to this or the provisions of the Texas Insurance Code and consistently refused to allow a second policy limit for claimants whose only claim is for mental anguish. And that is the case here, where again, we have one bodily injured person, one policy limit. And that doesn't mean that a claim for mental anguish wouldn't be covered under the policy. It only means that it doesn't trigger a second policy limit. Unless the court has any further questions, I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
So please, the court, good afternoon, your honors. I want to clarify a couple of things before I get into my argument. McGovern was a case that did deal with a car insurance limit, but it also was a loss of consortium claim. It did not include any kind of bystander claim in that opinion. Just to clarify your question, your honor.
Why is that a material difference?
Loss of consortium claims, wrongful death claims, loss of household services have been routinely set aside from bystander claims in Texas law as derivative claims. Derivative claims cannot get a second limit. The case law is clear and the appellee is not in any kind of disagreement with that case law. But bystander claims also have been treated separately. They are not derivative claims. Just because they share some of the characteristics of a derivative claim, the case law is very clear that they are not. Therefore, they need to be treated differently. And cases dealing with traditionally derivative claims that we're speaking of should not have the law applied to them the same way as a bystander claim would.
What's your best case that bystander mental anguish would not qualify as a derivative claim?
There are several, your honor. Most of the case law, speaking of this, does come out of the 14th Court of Appeals. AM Insurance, Life Insurance, and versus Rubicabla, does say that bystander claims are separate or independent claims. The appellate actually cited this case to say that bystanders are not derivative claims in order to show that they can only, a bystander claim is limited by comparative fault in a case tried regarding the underlying injured person's fault. So they're saying these have the same characteristics, they're the same thing, but that case itself specifically says they're not the same thing.
So your point is that the mental anguish claimed by Melody is not derivative?
Yes, your honor.
I'm sorry, what was that? Would you say that again?
Yes, sir. Melody's claim as a bystander is not derivative and therefore is not limited by an individual each person insurance limit under Texas law and even under the policy in this case.
If it's not derivative, and if you agree that Melody suffered no bodily injury, then how does she get any coverage under the policy?
Thank you for that point, your honor. The contract in this case has specific language that says they will pay damages to a covered person, Melody, because of the bodily injury to a covered person, Jamie. The language in that policy is very clear to not say we cover all damages to a covered person because of the bodily injury of the covered person. It can be two separate things. Appellant agrees in their motion or in their brief that it can mean two different things. It means both that the appellant will pay will pay damages to Jamie, the daughter, because of the bodily injury of Jamie, and that it means they will pay damages to Melody, the mother, because of the bodily injuries to Jamie. In their brief, they then make the leap without any explanation that says, because we already paid Jamie, we do not have to pay Melody.
Could you speak to the stipulation of or agreement that you have with the other side? Is that the law of the case? Was there an agreement that there was only one bodily injury?
Your Honor, there is an agreement in the stipulations, which I do believe was attached by both sides as an exhibit in this case, that Jamie did suffer bodily injury and that Melody did not suffer bodily injury. And
How is that not the law of the case then?
yes, Your Honor. Under Texas law, we have, this court, the 14th, has actually established bystander claims as separate and apart. That they are allowed to get damages for mental anguish damages without having bodily injury. The reason for that is that the bystander is contemporaneously involved in the wreck. It's not like a loss of consortium case where a husband is home and his wife is injured and he deals with the repercussions of her injury. They are actually involved in the wreck. They're suffering their own injury because of that. And they are supposed to be treated differently, which is why it's been so clear that they're not derivative claims and they should not be treated as derivative claims.
So could you try to address again the stipulation of evidence or the stipulation or agreement of the parties? Why is that not the law of the case in this one, in this case?
I'm sorry, I'm not sure I understand your question. Do you mind saying it again?
Your agreement that there was no bodily injury, why is that not the law of the case in this case?
Because I think while they say that the insuring agreement only insures bodily injury, we know that not to be the case. Insurance policies with the exact same language routinely cover emotional damages only, pain and suffering, mental anguish, all those things. So the bystander claim is allowed to have a second limit because of the difference in their experience getting these claims.
You don't contend, though, that the limit of liability language in the policy, you don't contend that's ambiguous, do you?
I wouldn't say that it's ambiguous, but I do believe that it does not follow the statutorily required language of the insurance code. And the way that they have phrased it, I do think it makes it confusing, if not ambiguous. I believe that it was miscited as the appellant as the insurance code section 1952.105. It's actually 104. And it does say, the language of that does make it very clear that the limit of liability for one individual who is injured is the $50,000 limit.
What part of the language, what part of this clause of the limited liability language differs from the code? You said it was different.
The way that they have, so in the code, it's all one phrase, and if you don't mind me just reading it out to you, it says, UIM and UM coverage must provide that regardless of the number of persons insured, policies or bonds applicable, vehicles involved or claims made, the total aggregate limit of liability to any one person who sustains bodily injury or property damage as a result of a single occurrence may not exceed the limit of liability for those coverages as stated in the insurance policy. And the second part of that is that the total aggregate limit of liability for all claimants, if more than one, may not exceed the total limit of liability per occurrence as stated in the policy. In the policy language in this case, they separate out the first clause of this language saying that this says, I think they list out, it doesn't matter how many claimants are involved, how many policies are involved, how many cars are involved. And I think they're trying to say, well, that actually limits the language that gives one person one limit and one person a second limit.
Your research hasn't discovered, neither side discovered the case of Carlson versus State Farm Mutual Auto Insurance Company. Are you familiar with that case?
I am not, Your Honor.
Okay, if you don't mind, I'll just read a sentence or two. So in this Northern District of Texas federal case, the court ruled that evidence that wife who was traveling in a separate vehicle directly behind the car driven by her husband witnessed accident that left him severely injured and trapped in a car, thereafter suffered extreme emotional distress manifested by physical symptoms, was sufficient to find that she suffered bodily injury as a result of sensory and contemporaneous observance of accident. Rather than seeing the husband in the hospital is required to support a claim for bystander damages. So this case is perhaps persuasive, may not be binding, But it seems to indicate that the bystander agreement, the bystander is a bodily injury sufficient to support a claim under UM. This is a UM policy claim. So maybe a case you might want to submit something on and maybe argue later on. I hope to get the other side's thoughts on this opinion as well.
Yes, Your Honor, thank you. And I believe that that case did refuse to follow Ginn versus Texas Farmers Insurance, which is an unpublished case that the appellant has tried to use to say that there does need to be bodily injury for a bystander. If the court is inclined to believe that there is any kind of physical manifestation is required, it was pled in the petition that Melody had suffered past and future pain as well as mental
How might
anguish.
you characterize an auto insurance policy? Is that an all peril claim, or is it specific? Do you have any thoughts on that?
I do not, but if I'd be happy to submit a memorandum brief on that if you would like me to brief that opinion later.
That's all right. Thank you.
Thank you, Your Honor.
I didn't read your brief as arguing that Melody's mental anguish constituted bodily injury. Did I misread your brief?
No, Your Honor, we stipulated that she is not saying that she has bodily injury.
Okay.
I think what the case law that we're speaking about says is that the bystander is an injured party under the language of that case law. And so the mental anguish itself creates an injured party for purposes of insurance, the insurance policies. I do want to briefly talk about also the contract language. Appellant did say that routinely insurance companies are not paying a second standard or a second each person policy limit to bystander claims. I do not believe that is correct. In fact, in this case, what it was mentioned in the reply of the appellant that Melody has recovered $200,000 in settlement funds for her bystander claim already. $50,000 of that is from a Safeco UIM policy, and $100,055 was from a progressive UIM policy. Because the statutory language is what controls UIM policies, I do believe it's persuasive in this case that other companies are routinely paying a second limit for bystander claims.
How do you distinguish the case of Christian versus Charter Oak?
Yes, Your Honor. So Christian versus Carter Oak deals with a mother or a wife and son who brought a wrongful death claim, which they would receive the funds for, and brought a bystander claim, which they would receive the funds for. As I spoke about before, derivative claims are very clearly wrongful death claims. And so for them to try to basically double dip on the policy would be definitely something that would be difficult for insurance companies to predict when they look at their liability in the future. In this case, Jamie Blanick was so injured that she surely deserved more than the $50,000 in the limited liability. I'm sure everybody would agree with that. But she could never come to a point where she can get both of each person limits because of different claims that she has. She can't get one limit for her bodily injury and one for her mental anguish. She is limited by each person, but Melody is not. And so that would be the difference, is that they are limited to each person, and by bringing a wrongful death claim, they can't also bring a bystander claim. And that also comes out in Herman Hospital, where a father was a bystander. He disclaimed any interest in the wrongful death claim and went forward with the bystander claim and was allowed to get a second limit for that under the TTCA. And I think the way the TTCA has worked under the 14th Court of Appeals doctrine is that under the TTCA, bystander claims can get a second limit, but derivative claims, loss of consortium, wrongful death, they cannot. And while it's not the exact same language, we don't have specific cases on bystander claims that show one way or another. And it's the exact same issue before this court again. We need to treat derivative claims and bystander claims differently because of the facts of the case. Those claimants need to be able to get more coverages under the law than derivative claimants.
Wouldn't it be easier for insurance companies to just write the policy different to say that?
And yes, I agree. I think if they want to disclaim that they do not cover mental anguish damages, put a definition of bodily injury in their contract, in their policy, which they didn't do in this case. My time is up. If there's any other questions, I'd be happy to answer. If not, my prayer would be that you uphold the trial court finding of granting Abilene motion for summary judgment. Thank you for your time.
I want to address 3 points in my rebuttal. The first is the derivative point, and then Justice Zimmer, I'd like to talk about the bodily injury point, and then finally the point about the other policies in this case. So first off, whether or not Melody's claim is derivative, frankly, Your Honors, that goes to a question of whether there's coverage under the policy, and Farmers doesn't dispute that her claim is covered under the policy. What is actually, I think, going on here is whether or not, even if her claim is covered, whether she can is she entitled to any more under a policy limit that has already been fully exhausted by the limit of liability? And the answer to that is no. So I think that can clear up the derivative question because, again, Farmers does not dispute that. Second, as to the bodily injury point, the parties have stipulated that Melody did not sustain bodily injury, and that is the law of this case. There's no doubt that she did not sustain bodily injury. And I think the case law as well bears that out because as the policy does not define it, we have to look at the common meaning of bodily injury. To the point of whether a bystander could be considered to have suffered bodily injury, there is actually case law discussing that, and that is City of Austin versus Davis, in which a father was considered a bystander and also allowed to recover under the Texas Tort Claims Act. And there, the court based its holding on the fact that he could recover for his bodily injuries because the parties stipulated that even though he was a bystander and was bringing a mental anguish claim, they stipulated that he sustained bodily injury. Also relevant is Trinity Universal v. Cowan, in which the Texas Supreme Court went the other way. There, it was not a bystander claim, but it was a claim for pure mental anguish. And there, the court considered whether the claimant who was claiming mental anguish was entitled to another policy limit under language tying policy limit to bodily injury. And the court said no, because it very expressly and clearly held that pure mental anguish is not a bodily injury. And the court went on to say that, in fact, if the claimant had pled her bodily injuries, for example, I think in that case it was, there had been testimony that she had stomach aches or loss of sleeplessness. The court said that there were circumstances in which physical manifestations of mental anguish could perhaps satisfy this each bodily injured person standard. That is not the case here. There is no evidence in the record of any bodily injury, and the parties have stipulated that Melody did not sustain any. Jamie is the only one who sustained bodily injury. Therefore, there's only one $50,000 policy limit at play, and that policy limit has already been fully paid out. And my final point is to about the other policies at issue. Appellee suggests that we can assume what was in this policy language. We cannot. Those policies are not before the court at the summary judgment stage. They're not in the summary judgment record. We don't know what the exact language of those policies is. And what we care about is the exact language of this policy. And this policy ties the $50,000 limit to a bodily injured person. And again, one bodily injured person, one $50,000 limit. I think that makes this a much more straightforward case than if we were to simply guess at what other policies were involved. Justice Zimmer, did I answer your question about bodily injury?
No, you made your arguments clear, that's true. But what about this Northern District of Texas case that seems to indicate that bystander emotional injury and sensory and contemporaneous observance of the accident, rather than seeing somebody after the fact, supported a claim for bystander damages? This is a policy interpretation by the Northern District of Texas.
Yes, Your Honor.
And you didn't cite it, they didn't cite it, so I'm not holding you to, having to address this immediately, but it might be something you'd like to submit, follow up on it. I would appreciate that.
Yes, Your Honor. I will note there again, what's at issue is not whether a bystander under this policy can recover damages. They can, because the policy language says that farmers will pay damages which a covered person is entitled to recover because of bodily injury. And for bystander, contemporaneously seeing someone else's bodily injury, specifically a close relative, that is an essential element of a bystander claim. However, it's also that a bystander did not themselves sustain bodily injury.
Well, that's what this case addresses. It says that severely injured and trapped in the car, the physical symptoms was sufficient to find that she suffered bodily injury. So there's a case that's persuasive that indicates that emotional bystander damages can constitute a bodily injury under Texas insurance law. So that's the issue that you're asking us to address. And I'm just suggesting that there are some cases that indicates otherwise. I'm particularly interested in, the insurance code requires those two elements, property damage and bodily injury. And of course, every insurance policy follows and tracks the requirements. Let me go finish my question. I'll let you answer. I hope he'll let you answer. And it's been the practice, I think, of most insurance companies that an insured anticipates that if they purchase a policy, they've actually purchased a policy that will cover them as a first person for injuries that they sustain that would be liable, the other party would be liable for. You're not suggesting that the other party wouldn't be liable for her bystander injuries, are you?
No, Your Honor.
Okay, so the real question is whether or not the insurance company agreed to indemnify that. And so one of the things that I would like to hear from you is how you might address the consumer's right to know what is covered and not covered by an insurance policy they're paying for.
Well, Your Honor, again, just to clarify that under this case, Farmers is not disputing coverage. What it's disputing is an additional policy limit payout. So back to Justice Jewell's earlier example.
It's a damage. It's a question of damages. You're not suggesting that there's no such thing as a bystander claim. You're not suggesting that the original defendant wasn't required or wasn't obligated to pay for bystander damages. You're suggesting that your policy limits that recovery. And you're claiming that it's based upon a definition of bodily injury. I got that. I understand that. But is there an overarching public policy interest that people who purchase policies and they're paying money for it ought to know what's covered and not covered?
I think certainly a party should know what's covered and what's not.
If you want to exclude that, you could have included an exclusionary language in your policy.
Yes, however, Your Honor,
And other insurance companies, since I believe 1980 was when the insurance code required policies to be offered, have historically paid those claims. So I understand the arguments. I'm just wondering if there might be some other overarching issues that you're asking us to disregard.
No, Your Honor, because in this policy, there would not be a need for an exclusionary provision for bystander injuries, because again, we're not disputing that a bystander injury is because of bodily injury to another. The only thing that comes into play to limit that is the same thing that would come into play to limit, for example, someone else's bodily injury. As Appellee pointed out, Jamie, the daughter, perhaps is entitled to far more than the $50,000 that she is entitled to recover. But under this policy, even her claim is limited to the same $50,000 each person limit. And so the issue is not, there would not be a need to exclude a bystander claim because the limit of liability is the stopgap that ends all claims, not just bystander claims, not just other derivative claims, not other independent claims. It all stops at $50,000.
Okay, so let me just ask one more question. Would you believe, is it your position that, bystander claims are derivative of the other party's injuries? That's basically your argument, is that right?
No, Your Honor. Our argument is that bystander injuries flow from another person's injuries, but are not derivative in the technical sense used in the Texas common law that says, they can't be brought independently of a primary claim. We agree here that Melody is entitled to bring her bystander claim totally independently of Jamie's. And in fact, if Jamie hadn't made a claim under this policy, of course, Melody would be just as entitled in that scenario as she is in this scenario to bring her claim to Farmers. However, she's not entitled to any coverage beyond the $50,000 limit. So for example, if, as Justice Jewell mentioned earlier, Jamie, had only taken $10,000 out of the policy, yes, of course, Melody, for her bystander damages, would be entitled to recover the remaining $40,000 underneath that $50,000 limit. And if there are no further questions, I see my time is up.
Thank you very much.
Thank you, Your Honors.
Thank you, counsel, for your arguments. We appreciate the briefing and the arguments today. The case of Farmers versus Blaylock is submitted. Counsel are excused and the court's adjourned.
Yeah.